Straight ahead on Law&Crime Daily. The Johnny Depp versus Amber Heard saga continues.
As against Amber Heard, we, the jury, award compensatory damages in the amount of $10 million.
Why Heard's attorneys say a juror improperly served in the case. And the Delhi Uvalde school shooting.
I'm using this pain to speak to you today as a Uvaldian and to speak for the parents and victims who seek the truth, transparency, and ultimately accountability.
An area pediatrician addresses the shooting's psychological fallout. Plus, Colorado versus Kevin Eastman.
The messages pretty much said that he was married to Mrs. Frank, to leave her alone, or he was going to, can I say it?
Yes.
He was going to kill me.
A victim's friend testifies about previous threats from the defendant. And later, police in Philadelphia search for a group of children who beat an elderly man to death with a traffic cone. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmire. Attorneys for Amber Heard now claim a juror was served improperly in the actress's recent defamation trial against ex-husband Johnny Depp. Last month, a Virginia jury ruled largely in favor of Depp, awarding the movie star $15 million in damages. The jury awarded Heard only $2 million in compensatory damages. The lawsuit stemmed from Heard's 2018 Washington Post op-ed saying she was a survivor of domestic abuse. Depp filed a $50 million lawsuit claiming his ex-wife defamed him by manufacturing stories of abuse. Heard pushed back with a counterclaim of $100 million, noting Depp was never mentioned by name in the article. Heard's attorneys now say newly discovered facts show issues with juror number 15. While a judge ruled the jurors' names would be temporarily sealed, Heard's attorneys say the juror who took part in the trial has the same last name as the person called and lives at the same address. In a memo filed last week, attorneys for Heard wrote in part, quote, "It's deeply troubling for an individual not summoned for jury duty nonetheless to appear for jury duty and serve on a jury." Heard's attorneys now argue her due process rights were violated when a person not summoned for jury duty appeared. They say a mistrial should be declared for the defamation suit. On Monday, Depp's attorneys filed a motion to strike this request. Joining us today is Palm Beach County State Attorney Dave Aronberg and co-host Terri Austin. Dave, it must be a civil thing because we can never get people to show up for criminal jury duty, but let's jump into this. If the mistake is that the wrong person showed up, but they were properly selected, does that still create a mistrial?
No mistrial. As long as you had voir dire, which is jury selection, you could vet the juror, and the juror was acceptable to both sides. So what that you had an honest mix-up? Now, if there was something nefarious where you have this guy, he went just for the sole purpose of ruling for Johnny Depp, and he somehow knew that that was the case he was going to be selected for. But I can pretty much assure you that this was an honest mistake. He took his father's subpoena, he went to court, and he was vetted and questioned and accepted by both sides. No mistrial.
All right, Dave, you want to show up for jury duty anytime for me? Let's do that. Now, Terri, how do you think the judge will respond to this? Because what Dave is saying makes perfect sense to me. It's like a harmless error type of situation. But will there be a hearing to question the juror?
Absolutely not. David's 100% right. That judge should dismiss the motion outright. In order to prevail on a motion like that, there has to be some prejudice, and there has to be a violation of Amber Heard's rights. There were no violations here. There's no prejudice. There's no need to question that juror. There's no need for a hearing. These jurors are selected randomly, usually with the driver's license or with a voter registration. And as David said, as long as there is a voir dire and that juror answered the questions honestly and there was no misconduct, absolutely this should go forward. And we should definitely not have a mistrial. I think the judge is not going to have a hearing, and he's going to just dismiss that motion outright.
Yeah, but hey, the defense has to make the motion. You have to represent your client. You got to go through the paces. I just don't think it's going to go anywhere. Well, in other celebrity news, Tesla CEO Elon Musk and social media giant Twitter could soon face off in a court battle after the SpaceX founder says he's backing out of a deal to purchase the site. Musk made the move in April to purchase Twitter for $44 billion, saying the site was limiting free speech. He said he wanted to take the company private, arguing he would be able to grow Twitter and make it more politically neutral. Musk and his lawyers now say he's backing out of the deal, accusing Twitter of withholding information about the number of spam and bot accounts on the platform. In the merger, Twitter and Musk had agreed if he were to back out, he would pay $1 billion in fines. Musk and his attorneys will have to prove Twitter breached the agreement in order to not pay that fine. Twitter claims it was being truthful about spam accounts numbers. On Friday, the social media giant said it plans to sue Musk to complete the sale, saying it's confident it would win in court. And in other celebrity news, rapper Kanye West faces new legal issues over allegedly failing to settle outstanding fees owed to a high-end fashion rental service. The lawsuit is brought by David Cassavant's Archive, a New York-based stylist whose private collection focuses on menwear that can be rented. The stylist is suing West for more than $400,000, saying West didn't return various rare esteemed pieces of designer clothing, which he borrowed dating back to October of 2020. Court documents say West owes the David Cassavant's Archive a little more than $220,000 in unpaid fees. The additional $195,000 sought is to replace the items if they are all lost entirely. The news of this new lawsuit comes just a week after West was also sued for alleged copyright infringements for his new album, Donda 2. That complaint argues West sampled a 1989 song in his latest work without consent or compensation. In celebrity news overseas, Prince Harry scores a victory in a defamation case against UK tabloid. Last week, a British judge sided with the prince, saying parts of an article published in the British publication The Mail defamed the Duke of Sussex. The article discussed Prince Harry's legal battle against the government after it denied his request to pay for police protection while his family is in Britain. When Prince Harry and his wife Meghan Markle stepped back from their royal duties in 2020, their family lost its publicly funded security. After that, Prince Harry offered to pay for security while in Britain, but was denied. On Friday, an English judge ruled in Prince Harry's favor in the initial phase of his libel case. Still ahead on Law and Crime Daily, a man stands trial for a double homicide in the state of Colorado. But first, the Uvalde sheriff testifies about the deadly school shooting, when we could expect to see a preliminary report about the massacre. Welcome back. Officials in Texas agreed to release surveillance video from the Delhi Uvalde school shooting. This as the city's sheriff testifies in front of the State House Committee. Back in May, an 18-year-old gunman opened fire at Robb Elementary School in Uvalde, Texas. 19 students and 2 teachers were killed in the massacre. The gunman was also killed. 17 others were injured. In the days following the shooting spree, law enforcement faced public scrutiny for their failure to react quickly. Reports say it took more than an hour for police to take down the shooter, as multiple 911 calls were made from inside the school, and several students inside yelled to the police who were outside. While the House Committee investigates the law enforcement response, 20 officers have been called to testify. On Monday, the Uvalde sheriff gave testimony via Zoom in a closed-door hearing. Officials say the preliminary report on the shooting could be released in the next 10 days. This as Uvalde pediatrician addressed the massacre at a White House press conference on Monday, applauding recently passed gun control legislation.
It's been tough being a pediatrician in a community where children do not want to return to school and parents don't want to send them there with the fear of a future attack. I see children daily with PTSD and anxiety that's now leading to depression. I spend half my days convincing kids that no one is coming for them and that they are safe knowing, and that they're safe. But how do I say that knowing that the very weapons used in the attack are still freely available? Let this only be the start of the movement towards the banning of assault weapons. As I have said before, adults are stubborn. We're resistant to change, even when the change will make things better for ourselves, but especially when we think we're immune to the fallout. As we have seen, no community is immune to the fallout. Rather, the fallout is landing in our backyard on a weekly basis.
Terri, how broad of an investigation could this be, and what changes do you believe will follow?
You know what, Brian? These types of investigations generally cast a wide and a very deep net. The Texas House of Representatives is going to have very wide latitude. They're going to thoroughly investigate this case. They've already said that they want to take a look at that hallway surveillance video, and they want footage to be accessible to the public because they think it's necessary for the public to understand what happened. They're going to call as many police officers and other witnesses as they deem necessary. And you better bet they're going to look at police policies, police procedures to try to determine whether or not they followed all of those procedures.
Now, Dave, this blew my mind, and I think it's going to do the same thing for you, but the chair of the committee, Representative Dustin Burrows, is prohibited from releasing the 77-minute quote-unquote hallway video because of an NDA with the sheriff's department. Does that make any sense, and is that right?
It's frustrating, Brian, but I understand how investigators, including the DA's office, are reluctant to release this video while there's an ongoing investigation. Now, the killer is dead, but there's an investigation going on about possible criminal conduct by people around who stood around and did nothing. So as long as that is possible, where you could have culpable negligence or child neglect, I can understand why they're not going to release that video yet, because you don't want the potential suspects to corroborate their stories, to lock down on some story after they watch the video. And you also don't want them to flee if they think they're about to be charged.
And that's why you're a prosecutor and I'm a public defender. You're making the right choices. It makes a lot of sense, Dave. And in political news, President Biden signs an executive order to protect abortion rights. President Biden signed the order on Friday in the wake of Roe versus Wade being overturned. The order allows Health and Human Services to protect access to contraception and medication abortion while maintaining patient privacy. President Biden also says the White House will create a task force on reproductive health care through which federal agencies could offer support for states with legal protection for providers and for out-of-state patients. At a press conference, President Biden explained the executive order, saying abortion rights could only be restored by voting.
The only way to fulfill and restore that right for women in this country is by voting, by exercising the power at the ballot box. Let me explain. We need 2 additional pro-choice senators and a pro-choice House to codify Roe as federal law. Your vote can make that a reality. I know it's frustrating, and it made a lot of people very angry, but the truth is this, and it's not just me saying it, it's what the court said. When you read the decision, the court has made clear it will not protect the rights of women, period, period. After having made a decision based on a reading of a document that was frozen in time in the 1860s, when women didn't even have the right to vote, the court now practically dares the women of America to go to the ballot box and restore the very rights they've just taken away.
Coming up on Law&Crime Daily, security video shows a group of teenagers attacking an elderly man with a traffic cone in Philadelphia. Plus, a Colorado man stands trial for a double homicide. The latest developments in the trial of Kevin Dean Eastman. Welcome back. A friend of one of the victims in the Colorado trial of Kevin Eastman takes the stand, telling jurors the defendant had threatened him before he allegedly killed his ex-girlfriend and her new love interest. Eastman is charged with 2 counts of first-degree murder, tampering with the deceased human body, and tampering with physical evidence for allegedly killing Heather Frank and local Greeley, Colorado musician Stanley Scott Sessions on separate days in February 2020. Frank and Eastman both had arrest warrants in connection to Sessions' murder before Frank's body was found. Prosecutors say Eastman slit Sessions' throat in Frank's apartment and that Eastman fatally shot Frank to silence the only witness to Sessions' killing. Investigators say Eastman burned Sessions' body and was allegedly preparing to burn Frank's body as well when he was arrested at a gas station. On Friday, Frank's friend testified for the prosecution. He told the jury Eastman had threatened him while he was spending time with Frank.
Can you tell the jury what those messages said?
The messages pretty much said that he was married to Mrs. Frank, to leave her alone, or he was going to, can I say it?
Yes.
He was going to kill me. He was going to stab me in the face, in the neck. He was a roughneck. He worked in the oil field, blah, blah, blah. And I was texting him back and forth, and I was like, whatever, you know, you guys have your own issues. But that's when I blocked him because I didn't know what the next step would be. We kind of cut off all contact,
Okay.
Heather and I, because I didn't want to be a part of that. I was going through my own things, and I was just like, this is toxic. I never knew she had him because she never talked about it. You know, she never talked who she was. She said, like, if they're, you know, I didn't know they were married when like he said they were married. What she did say is that he would show up at the Doug's Diner quite often, unannounced. You know, so that's where it kind of started, and she was in fear because she could never get away from him. He was always kind of lurking in the background.
All right, Terry and Dave, we've been talking about this testimony all day. Terry, how does this testimony fit into Eastman's guilt or innocence in terms of this case?
You know, I think the testimony is relevant, and I think it's probative. I don't think it's prejudicial. I think under Rule 404, it is allowed. I think that's why the judge allowed it. It is showing motive, and I think the motive is the same. This is a prior friend of Heather Frank's. He's saying that he was threatened by the defendant. And that's exactly what happened with Scott Sessions. He was threatened and ultimately killed by the defendant. So I definitely think it should be allowed, and I think the judge made the right decision.
All right, maybe it's the defense attorney, but I tend to disagree. And Dave, I love asking a prosecutor pro-defense questions. So here it is. I would argue that this information about Eastman threatening a person he isn't accused of a crime of doing is more prejudicial than probative. I threatened this other guy. It has nothing to do with what I did with my wife. So how does this come in?
This is a tough one, Brian, and Terry's got a good point because it could show motive. You have to establish that this goes to motive because how else are you going to show why Eastman killed Sessions? Why? Well, he was this jealous dude who was always lurking around and exaggerating his relationship with Frank. So that's the argument. Now, as a prosecutor, you have to be careful. And I'm sorry to equivocate on this because it is a close call. Because if you admit this into evidence, and as a prosecutor, if you don't absolutely have to have this to prove guilt, then you could be overturned on appeal. And that's the last thing prosecutors want to do. So if it's a close call, some prosecutors will be like, hey, let's take a step back, not use it because we got other good stuff instead. So it all depends on how important this piece of evidence is to make that decision whether to put it into evidence.
I'm calling it now. I'm calling it appellate argument. We'll see whether or not it actually works in the long run. Well, when we come back, a group of Philadelphia teens wanted for murder. Still ahead, we take a closer look at security camera footage showing the children brutally beating an elderly man to death. Welcome back. A pair of brothers, ages 10 and 14 years old, turned themselves over to Philadelphia police as part of a group who beat an elderly man to death with a traffic cone. Police released photos of the children involved and video of the attack last week, hoping that more information could lead to an arrest. It happened in the early morning hours of June 24th on the city's north side. Security video shows a group of 7 kids who authorities believe were teenagers beating a 73-year-old man with a traffic cone. While police did not release his name, local Philadelphia news outlet identified the 73-year-old as James Lampert, Jr., who went by the nickname Simmy. Security video shows Lampert being struck by the cone and falls to the ground. He died the next day. A $20,000 reward is now being offered for details leading to an arrest or conviction. Anyone with more information on the other children involved should contact the Philadelphia Police Department, Homicide Division. The phone number is now on your screen. Dave, this is Pennsylvania, but if this happened in Palm Beach, Florida, what charges would these young men be facing?
The ones who actually threw the cone at the victim could be charged with second-degree murder. And if they're 16 or 17 years old, they could be tried as an adult. The ones who didn't throw the cones would not be charged, most likely. And if they're under 16, they should be charged as juveniles.
Yeah. It'd be interesting to see whether or not, I know in New York we have this kind of accomplice liability, whether they get tacked on with that. But Terri, what are the next steps in this investigation for the other kids involved?
You know, now that two of these teenagers, basically 10 and 14, turn themselves in, I think the police are going to focus on them to try to determine whether or not they can get information. And the information obviously is identifying the other people involved. And you better believe those two children are going to be grilled to find out who was in that group. Beyond that, I think what the police are going to do is look at that surveillance video to determine some facial identity and to look at the hair. One of the videos showed that one of the children had a blonde spot in his or her hair, and look at the braids of the girls who had long braids to identify, and the bags that they were claiming. They had some identification on their shirts. And I'll tell you this, that $20,000 award will also help because people will be motivated to give more information.
Yeah, I anticipate a long and detailed investigation to find out who these are. Dave, Terri, thank you very much. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.